Good afternoon. We will just pick up where we have left off, and we'll just pick up where we have left off, and Mr. Charles Brown, you're still sworn to tell the truth.
Sure.
Counsel, when you're ready, you may proceed.
Thank you very much, madam. Good afternoon, sir.
Yes, good afternoon, Counsel.
We had concluded your presentation regarding the southern portion, and I'd like to ask you to continue with the presentation. I believe we're at page 31, which reads March 1968 through to April 1969, a northern portion.
Correct. Yes, thank you, and good afternoon, all. So the northern portion of the property, this is the piece of property that Mr. Russell Levi Perriman and Mr. John W. Swan have set their sights on. So what we've learned is that Mr. Russell Levi Perriman now enters the equation, and he submits an application to it was called the Central Planning Authority. We call it the Planning Department now. We just say up planning. But Russell Levi Perriman submitted an application to subdivide the northern portion, submitted that to the Department of Planning in 1968, March the 6th to be specific. Now, at the time Mr. Perriman submitted this application to subdivide, he was not the owner of this property, neither was he an agent acting on behalf of the owner. He was acting, he's not here to ask, but we believe he was acting on behalf of others, namely John W. Swan. The application was described as a plan of subdivision of Lot 4 of property, White Hill, Sands Parish, Bermuda. And you can see the stamp that was affixed to this application in the bottom of page 32, where it shows clearly the application number was S1180, and it was received on the 6th of March, 1968. And then you see it was granted.
I'm sorry, could I just ask you to change the slide?
Oh, That's why I hit you. Yes, sorry. Okay, here we are. Thank you, George. So just to recap, this slide here shows the plan of subdivision that was submitted by Mr. Russell Levi Perriman in March of 1968. And at the time, it was not on behalf of owner or agent, or as agent for the owner. Now that schematic, or that application to subdivide is reflected a little more graphically in the next page, plan number 9. I think 9 is written at the bottom of the plan. And you see a series of red dots, number 1 through to 8. And you see Eric Jones parked up on the southern portion. This was Russell Levi Perriman imposing himself on the northern portion. And some fine Bermudians live up on that property to date. And you can see the neighbors are still as they were. So this is 1968. And as we turn the page, we have a closer look at the documentation that was submitted to the planning department.
Can I just ask you to take us back to what the numbers represent?
So on this schematic here, sir?
Yes, thank you.
Yeah, the numbers here, number 1 through to 8 on the northern portion is lot number 1, lot number 2, lot number 3, etc., through to lot number 8 for the northern portion. And those lot references show up in a couple of slides, which we'll focus on them as well.
Okay.
At that time. So this slide shows the schematic of the subdivision application, which was eventually approved. So this is 8 lots. Moving on, as I said, having a closer look at the documentation that went to the planning department. There's the subdivision, and there's the letter from Mr. Pearman in the center. And then on the right-hand side is a letter from the planning department to the police indicating their position on Mr. Pearman's application. Now, as we have a closer look, even closer look at the documentation, we can see that the stamp on the next slide that says received February the 3rd, 1969. We submit that that date stamp has been tampered with by hand. There was an attempt to suggest that Russell Pearman's application was in fact made in 1969. But we know from the previous slide and from the stamp on the right-hand side of this page that it was submitted in 1968. The reason why this is important is because in 1968, Russell Pearman did not earn, nor did he claim ownership of the property in 1968. So it's important for planning department, Central Planning Authority, for their records to align with the notion that Pearman did not earn the property in 68, but he did earn it in 69. That's what the planning department needs to reflect. This is what we've concluded. So as we look at these stamps on this slide, we can see that the stamp on the left, I'm worked in offices. I've done a lot of stamping of documents coming and going. And date stamps don't look like this. They're not crooked. The lines are straight. But if you cut them from somewhere and attempt to misrepresent them, then they might look like what we're looking at. We submit that that date stamp's been tampered with. In fact, it says February 3rd, 1969. Now, 1969. Look at that second 9. That was tampered with by hand. That didn't come from no date stamp. Because if it did, the 9 and 19 would look like the 9 and 69. And those two ain't cut from the same cloth. That 19 is different from 69. In fact, if you get real funky, you can look at the 9 and 19, the 6 as in 69, and then the 9. They're all three supposed to be the same digit. Number 2 and number 3 is on the same page, but number 4 come from somewhere else. Okay, so that 9 has been manipulated by someone. And it wasn't my Uncle John. Russell Pearman submitted his application in 1968 as is shown in the stamp by the Central Planning Authority. Pearman's making misrepresentations to the Central Planning Authority that the application ran in 1969. There may have been an application in 1969, but it was approved a month later. Now, you know, a month to approve a subdivision for 8 lots at the Department of Planning? Not likely. Not likely. So, before we move on, I want to emphasize with this slide here in particular, the date stamp was tampered with. It's different from the date stamp that is on the subdivision application. And the timing of it, the timing of this stamp and this application is designed to demonstrate that Russell Levi Perman was the legitimate and bona fide owner of the property in 1969.
Before you move on, just for my general understanding, what appears to be the stamp in blue on the Building and Land Development
Yes,
application appears to be S/1180,
yes,
received in March 6, 1969.
1968.
68. Thank you. You're of the opinion that this document is also manipulated.
The March 6, 1968, we do not believe that was manipulated, but we believe the stamp on the middle document was manipulated.
And what appears on page 35 of the slide,
Yeah,
and what is on the extreme left where it has, which you pointed out to us, is crooked, received.
yes,
The word authority is superimposed or part of the word received.
yes.
You have February
Third.
3, 1969, Central Planning Authority per.
Yes,
You're saying that document has been manipulated, and you're of the opinion that it was done to give the impression that Pierman owned the property.
correct. And I would invite you, with respect, to remember that question, because we're going to look at some documents that represent Pierman's association with the property, and the dates are very important. So, yes, to answer your question, the February 3, 1969 stamp was manipulated by hand, and it forms part of the intent to suggest that Pierman owned this property at the time this stamp was affixed.
And just for completeness, even though you may have said it, based on your understanding, when in fact is it that he actually, we have what one is trying to, based on your impression, one is trying to present as if it is so, and the fact that it actually is so, two different things.
Sure.
So what is your understanding as to the point in time when Pierman actually owns?
Yeah. Pierman never owned. He lays claim to the ownership of the property, and he did so in January 11, 1969, when a sales agreement was crafted, and we'll come to that in a moment. And then there was a conveyance following the sales agreement for April 15, 1969. So January 11, 69, and then April 15, 69 are the two dates that they rely upon, and the documents associated with those dates they rely upon to say Russell's the owner.
Okay.
Okay? All right. And so as we move along from these date stamp examinations, we take a closer look at what the investigation by Mr. Casson surfaced. So this is the Central Planning Authority acknowledging in the course of the police investigation that Russell Pierman was regarded by this department as being the applicant and the owner. And it's very important that the applicant, the owner, or agent, that it is clear on whose behalf the application is being made. Someone has to be held accountable. But in any case, this is what they wrote to the police during the course of the investigation. Their view, their position is that Pierman was regarded as both applicant and owner of the land subject of this application. Okay, so that's the Department of Planning. Now we should know or be reminded that at the Department of Planning, now remember this is the 60s we're talking about, right? Bermuda social profile was racist and so forth. In the 60s, a Mr. Murdia, we didn't get his first name, but a Mr. Murdia was a senior officer in the Department of Planning. And we suspect, given Murdia's involvement in this property deal to date, that there's probably an association between the two, and the Mr. Murdia, who we do not know, may have been instrumental in some of these lines and some of these nines not lining up.
But he or someone else?
Or someone under his supervision. But we know that Murdia worked there, and we know that Murdia's got his fingerprints on the southern portion, and he's got his eyes on the northern portion. And so we have associated this unnamed Murdia with this transaction. So we move on. So that's the planning department looking out for Russell Perriman as it relates to his legitimacy as an applicant to request some subdivision. So now we look at a letter, February 19th, 1969. Here's Robert Murdia. Again, him and Wilkinson. We call him Wilkie. Affectionately, we call him Wilkie. Yeah, so here's Murdia writing to Wilkinson. And Murdia says, on instructions of Mr. John Augustus Alexander Virgil, we forward to you herewith the title deeds of a property in Sands Parish, which we understand that Mr. Virgil has contracted to sell to your client, Mr. Russell Levi Perriman.
I'm sorry, what slide are you on?
We're on number 37.
Okay, thank you.
Yes, so this is a transcribed letter from Robert Murdia to David Wilkinson concerning the northern portion.
Okay.
And Murdia is saying to Wilkinson, we understand that Russell Perriman buying the property for $7,000. So this is lawyer to lawyer. This is what Walden called legalism. Legalism at work. Lawyer to lawyer. So he goes on to talk about the price of $7,000. But he says, point 3, we have a copy of a form of a contract for sale. That's a sales agreement dated the 11th of January, 1969. He said it's got a sales agreement. All right? Now remember, this is Robert Murdia, who's the lawyer for John Augustus Alexander Virgil, help him write the will. And now he's telling his friend David Wilkinson that his client, Mr. Virgil, is selling the property to your client, Mr. Perriman. And it's a cash transaction. Yeah. Murdia says to Wilkinson, it's going to be paid in cash. Okay? Now, Murdia is the lawyer for Augustus Virgil. And his claim, and Virgil said, was selling this property to Russell, and we got a sales agreement. So we're going to have a look at the sales agreement on the next slide. So here's the sales agreement dated January 11, 1969, duly stamped. Now, I acknowledge it's not blue ink, and it's not that dense, but this is the sales agreement that Russell Perriman's relying upon to claim ownership of the northern portion. And on the right-hand side of your slide, in front of you, okay, it's up now. So on the left-hand side is the sales agreement, signed by someone who wrote John Augustus Virgil. Now, the gentleman that owns the property, his signature's on the same page. It's authentic. It's at the top on the right. John Augustus Alexander Virgil's his name. Russell Perriman's representing that this sales agreement, signed by him, witnessed by Algin and Dewis, which we'll talk about a little later, was the basis upon which Uncle John sold this property to Russell Perriman. Now, without being a handwriting expert, which none of us presumably are, but you know when somebody signs your name. and you know what your signature looks like. So here we have an analysis of the three signatures. We have the signature from Uncle John's will at the top of the page. In the middle, number 1, the bottom, number 2. These are two sales agreements that Russell Perriman made use of. Both of them dated 11th of January, 1969. Two sales agreements, two different Johns, two different Augustus, two different Virgil. No Alexander. You're signing a sales agreement for half your property and you didn't put your full name? Maybe. We think otherwise. So it is our view, our position, three different people, and I think Russell knows, three different people signed these three documents. And two of them are supposedly by the same person. By the number 1 and number 2, supposedly signed by John Augustus Alexander Virgil. So if you analyze these signatures without going into a lot of detail, you can look at the J in the John. And, you know, I'm not an expert either, but I know what a looped J looks like and what a straightforward J looks like. And I know what an A looks like when it's connected at the top and when it's not. So look at the John and look at Augustus and ask yourself if a handwriting expert could change your mind or perhaps influence you. Do you have unreadiness with respect to the analysis of these signatures? So those are the signatures that were relied upon to confirm that my great uncle sold the northern portion of his property to Russell Levi Perriman in 1969. That's the signature. And you should know that Russell has gone on to say, or at least the witnesses out there indoors, we drove around in a taxi. And they set off in the back seat of a taxi up around 42nd Street, Government Gate, and signed away the northern portion of this property. And John Augustus Alexander Virgil was not even in the neighborhood. He weren't in the taxi, he weren't in the neighborhood, he wasn't to be found. But these are the documents that Russell Perriman, Robert Murdia, John Swan, and others rely upon to lay claim to the northern portion of his property. Yeah. And Mr. Dawes' name was just called regarding him witnessing the sales agreement. Mr. Dawes was interviewed by the police, and we'll talk a little bit in detail later on about Mr. Dawes' contribution to this transaction. Okay, so that's the analysis of the signatures that are relied upon to legitimize this transaction. Now, as you would know, when it comes to property transactions, we've learned over the course of time that you need a sales agreement and you need a conveyance. Sometimes the conveyance is voluntary, sometimes it's not, but you need some paper. And these papers have to be signed. So as we turn the page, we look at the conveyance that was used in April 1969. Remember we talked about April 1969 being a pivotal date because in 1969, Russell got approval from the planning department to say he was the legitimate owner of the property by way of his application, and we are now approving the subdivision, all connected. April 15, 1969, here's a conveyance.
Just 1 minute, sir. In respect of the handwriting, the signatures that you draw attention to, and also you had said that, well, you're no handwriting expert. Is there any member of your family to whom the signature, well, is there any member of your family who could identify the signature of your granduncle?
Yes.
Had that person been shown the documents at
Yes.
any time?
Yes, yeah. My mother is aware of his signature. And
Had she ever been shown the documents which purport to be to sign, which you say were signed by somebody else?
Yes.
Did she offer a comment?
Yes, she did.
Or what was that?
Nonsense, garbage, junk, ridiculous. He didn't sign this. This is not my uncle signature.
Yeah.
Words to that effect.
To your present knowledge, and even though I'm sure you can't give evidence for your mother, but can you say at that time about how old was your mother at that time when she had told you that? I'm just trying to get where I'm trying to get is I'd like to know prior to that how long she knew herself, knew her uncle, how long she had been accustomed to seeing his handwriting, how long she had seen him sign, how many years she should have, how often she would have seen him his signature, whether she had seen many documents. I'm just trying to get to understand the who, what, why, where, when, how, in terms of that knowledge to dispute that it is not his.
Well,
we could make a note of it and come back.
Certainly.
But it's something that, especially based on what you have said,
yeah.
I am interested to know that answer. But we can come to it after.
Okay.
But it's very important.
Okay. And but you should know, Counsel, that the signature that we draw reference to regarding his will,
yes,
is the signature that Robert Murdia. It was the signature that he had fixed to the will when it was arranged by Appleby's Robert Murdia, and then the bank was the executor. So we're using the signature from his last will and testament as an authentic signature.
Okay, well, and that's fine. The naked eye is good. However, just for clarity from a legal standpoint, in the absence of a handwriting expert, it is sufficient for us to have somebody speak to his handwriting and his signature. But I'll make a note of it and come back to it later. But I just wish to alert you to the fact that you will be asked questions along that line.
Okay. Yeah. There was. Okay, so the second. Where are we?
You're on page. I think you're on slide 40.
40, yes. So I want to draw the commissioner's attention to the conveyance that was relied upon. Now, this 1969 conveyance was not offered. It was refused. There was refusal to share. There was refusal to share this conveyance, either to see it or to have a copy of it. But it has eventually surfaced, and the signature that's attached to the conveyance is unlike the signature attached to the will. And again, we submit that someone other than our uncle signed this conveyance.
Thank you.
And so with that, we now look to assess 4 signatures drawn from documents that are used in part to justify the legal claim to the northern portion of this land. And at the top of page 41, you see the signature from Uncle John's will. Then you see sales agreement 1 and 2, which was used, and then we see the signature that was affixed to the conveyance that was also used to justify the sale in 1969. Moving on. And so this schematic from 1969 would see this subdivision. This was the wish, this was the plan to subdivide the property. This is what would have happened, was what in fact did happen, because this plan was approved by the planning department in 69. And shortly after this approval, Later on, the property was sold by Russell Levi Perriman to a gentleman, Emmanuel Augustus, on the same day. The same day that our uncle supposedly sold this northern portion to Russell Levi Perriman, Russell Levi Perriman sells the same property to a gentleman, Emmanuel Augustus. And Emmanuel Augustus is a client of John W. Swan Limited. Okay, he's a client. We haven't seen any sales agreements. We haven't seen any conveyances. But we do know that Emmanuel Augustus was a client of John Swan's, and he bought the property from Russell Perriman for $18,000 on the same day that Russell supposedly bought it from Uncle John. So very tight timelines indeed. Now, shortly after Russell takes claim, sells it to Emmanuel Augustus, who then sits on it for almost a year and sells it to John Swan, May 21st, 1970, for £60,000. So the sales price went from $7,000 last year to $60,000 this year. Money, muscle, and power at play. $7,000 becomes $60,000 in 12 months. And Emmanuel was just a client. Never met anybody, never signed any papers. He just said John was acting on my behalf. And ladies and gentlemen, we have a flurry of conveyances that took place soon after John Swan took possession of this property in May. You can see on slide 43 that there's a series of conveyances between John William David Swan and Leslie Earl Mean, signed off by Arnold Francis, the lawyer. And the reference, as you can see, is Book 17, page 108. And John William David Swan and Leslie Earl Mean, well, let's just say they were busy during the weeks of November and December 1970. A series of 10 conveyances to and from themselves. Now, I've never practiced real estate. Suspected maybe one or two in the room who have, but a conveyance from him to him in this time? I mean, you can't even sell a bag of oranges in this time. And these guys, look at this. 10 conveyances in 10 minutes, for the most part. I mean, asking people...
Same day.
Yes.
Yes, yes. Probably not 10 minutes.
All manner of ridiculousness and unreasonable expectations on the eyes of a reader to accept that these transactions took place in a legitimate form and fashion.
Just before we go any further, I know you're taking us through the presentation, but earlier I recall, probably 5 minutes ago, if that long, you had made reference to the consideration changing from $7,000 to what was the figure you gave? 60.
Yes.
But I'm not seeing that on the slide. Do you have that somewhere else?
We have
You'll come to it. You'll come to it eventually.
We'll come to it eventually.
Okay,
Yeah, we do have that information.
I was just
And it's in the, yeah. Yeah.
I was just following your presentation. You made reference to it, and I was not seeing it here. So I was just trying to ask you.
Okay. And it has
to
not.
assist me.
We have not yet mentioned it.
Okay.
In the but it comes up in the police report that we reference. With the witness statements in the police report.
Okay.
My brother's just pointed out to me that we have not yet gotten there, so I might have mentioned something a little slightly prematurely.
Okay.
In any case, we are on slide 43, where
Yes.
we observe in the flurry of conveyances between John William David Swan and Leslie Earl Mean in November 1970.
Thank you.
Okay, and from there, we look to sort of recap some of the activity that took place during this time period. And we put this timeline together for, hopefully it will be of some use to the panel in terms of understanding what's happened and when it happened. So here we are in March 68, where Russell Perriman submits an application. He wasn't the earner, neither was he acting on behalf of the earners. We saw the fraudulent behavior with the 6 and the 9 being manipulated. So there was misbehavior at play. And then step 2, we see the sales agreement was prepared, indicating that Virgil sold this property to Russell Perriman for £7,000, which we dispute. But on February 19th, Murdia was interviewed. I'm sorry, when Murdia was interviewed, he indicated that Virgil came to see him. This would be Uncle John Virgil came to see him on February 1969. And it's the same day that Murdia advised Wilkinson of the plans to sell the property. Pass me your deeds, and off they went. March 1969, March 7.
Just to guide us, you're reminding us that there was a memorandum that referenced this earlier. That's what you mean here by the summary.
Yes.
Okay, it's just that we just want to be clear so that we can join the dots.
Okay.
Just a moment, please.
Certainly.
I'm just trying to remind myself of the evidence we had before
With
lunch, Madam Chairman. I'm just trying to connect the dots. Could you just take us back to that slide? I know we're at
which one?
44. I was just trying for clarity. You're actually on page 44.
Yes.
You made with reference to item number 4, and you were speaking. And then you made reference to what my recollection tells me was a memorandum which had been sent to give me my deed.
Yes.
I'm just asking you to take us back to where we were earlier, where the memorandum was mentioned.
Okay.
So that the commissioners can see exactly what you're making reference to.
Yes.
And the page, and take us back to the slide, please.
Okay. The slide we are on now, page 44, makes reference to item 4, or step 4, where it says February 19, 1969. A letter from Robert Murdia advises David Wilkinson of instructions from Virgil on the transfer of his land.
Yes.
That is the letter on page 37 that we refer to. And that letter also states it's from Murdia.
You could just take us, I just asked you to take us back there.
It's this letter here on screen now.
It's at page 37.
Yes, page 37. It's the letter we are referring to on page 41, item 4. So,
Yes.
not yet, later when you get closer.
Thank you.
So are we okay that the
Yes.
letter? Okay.
Yes, I'm just trying to ensure that we follow.
So shall I go back to 44 now?
Thank you.
Yes? Okay, so that was step 4. Step 5, we mentioned the subdivision being approved a year later in 69. And now April 15, 1969. 4 important steps took place this day. Also remember that it was this time that Wilkinson said, I got a letter here, a memo that confirms an indenture between John Augustus Virgil and Eric Jones. So that was an attempt to backfill, as we say, for the northern portion to take effect. You needed to stand on the south in order to effect the north. So April 15, 1969, there was an indenture drawn up that supposedly transferred land from John Augustus to Russell Perriman for $7,000, and then the parish vestry was notified in step 7, and the parish vestry was considered the authenticating office at the time for a lot of land transactions. Step number 8, Butterfield reported that the property was conveyed to Russell Perriman on this date. And it goes on to state that the same date, April 15, 1969, Russell Perriman then sold the property, same piece of property, on the same day, sold it to John Swan's client for $18,000. And then just over a year later, he conveyed it to John Swan, his agent, for $60,000. And both Emmanuel Augustus and Dewars speak about this in their police interviews. So that's the timeline from 1968 through 1970 as relates to these activities for the northern portion. We had Murdia, Wilkinson, Perriman, and Swan all playing an important part in effecting this claim of ownership to the northern portion.
Can you just repeat the names for me that associate with each picture?
Sure. From the left, Robert Motia,
Yes.
David Wilkinson,
Yes.
Russell Perriman, and John Swan.
Thank you.
You're welcome. And yeah, but he didn't feature in all this. This is this recap of this. Okay, so the northern portion, as we wind on our analysis of the northern portion, there are 12 issues that we've identified that we'd like for the panel to consider as it relates to the legality, legitimacy, the reasonableness of this so-called claim of ownership to the northern portion. So the first point is that Perriman, Russell Levi Perriman, was neither owner nor acting on behalf of the owner when he submitted the application. So as far as we're concerned, that was a fraudulent step to misrepresent ownership of property to the planning authority for subdivision. The second point is that the planning authority, we believe, were not being straight when they testified to the police that the application was submitted in 69. And we know that the 69 was manipulated, and we know that the subdivision plan was submitted in 1968 because we've got a stamp to prove that. But yet the planning department said they received them both in 69, and they assumed that Russell was acting on behalf or as owner and agent. The third piece is that Russell Perriman did not purchase any property from my great uncle. Russell Perriman did not purchase any property from John Augustus Alexander Virgil. Now, you heard us mention the government gate location. Well, part of this real estate transaction was conducted in the back seat of a taxi while they were parked up outside government gate, just around on the 42nd Street side, and the seller was not present. Now picture that. Russell Perriman, Member of Parliament, how do you conduct real estate transaction in the backseat of a taxi? 1969. Things were done differently.
What are you placing reliance on in respect of that statement that the transaction was conducted in the backseat of a taxi?
Yeah, we haven't gotten to the police report yet, but during the police investigation, the witness to the sales agreement, Mr. Doers,
Said something.
yes,
Yeah, because,
to that effect. And we hadn't introduced that piece prior to making mention of it here.
Okay,
Apologies
because
for that.
I was not following in that regard.
Okay, but you caught that we hadn't mentioned police, and so, yeah, we'll raise that in a moment.
Okay.
Okay, and item 6, the sixth issue is that Mr. Doers, who we'll talk about in a moment, he signed once. He was adamant that he only signed once to a sales agreement, and his signature was used on 2 occasions to complete 2 separate transactions on the same property, the same day. Yeah? A further part of the police investigation, which we'll touch on in detail in a moment, was Detective Inspector Waddle. He indicated that the signatures on the sales agreements, they weren't the same. Now, I don't know if he was an expert, but he said they weren't the same. And a lot of people agree with him. Presumably an expert would as well. But we don't know if he was an expert, but he did make the comment. This next point that is an issue is that the conveyance of the 15th of April, 1969, it was not signed by John Augustus Alexander Virgil. We saw their signatures, and they were not signed by the same person. Another issue is that the Registry General's Office, which has a responsibility for holding all legal documents related to property transfers, they hold no record of any transaction on this property after 1962.
When last was a search done in this regard?
Our search was done in 96 during the course of the report being conducted by Bermuda Caribbean Engineering Consultants Limited.
Okay, so up to
1996 was the date that we confirmed that there was no record of any sale on this property after 1962.
Thank you.
Now, the next point we raise is Russell Perriman's lawyer, Mr. David Wilkinson, who eventually became Speaker in the House of Assembly in Bermuda. Yes, I think there's pictures hanging in the Honorable House of Assembly. He was asked during the course of this investigation, Mr. Wilkinson, may I please have sight of this pivotal indenture? Wilkinson said no. He refused to cooperate with the police. So the police asked, well, may I have a copy? He refused. This is in the police report. Mr. Wilkinson refused to cooperate and allow the investigators to have sight of the document that he represented to the government confirms the sale of the northern property. He refused to share it. We also know that John Swan Limited, they didn't produce any documentation on request either. The police report concludes, or at the time they concluded their report, they indicated that they were still waiting for the relevant indenture. We have since seen what is posited as the conveyance for that period, and we've seen the signature. And this was 7, 8, 9 months after the sale supposedly took place. So, problem there. And as we mentioned at the top of our story, the beneficiaries have held and continue to hold the title deeds. And so this transaction for the northern part of this property would have to square with those deeds, and it does not. So that's the 12 issues that we invite consideration of as we claim that transactions on the northern portion are not rooted in legality. And so with that, Madam Chair, I'd like to move now to the third portion of our story, which is our pursuit of justice.
Has Council any comments before he moves on?
Not at this time, Madam Chair. We think we have some way to go because all of this we have to go through to have the supporting documents appended.
Go ahead, please, Mr. Brown. You may proceed.
Okay, thank you. Thank you. And so I mentioned my 88-year-old mother earlier today. She's got her brother here, Glenn's here. She's got her stalwart nephew here, who's Aunt Sophia's son, Donald. These folks have pursued justice up and down this country since 1972. I suspect some people in this room weren't born in 1972, and maybe some listening weren't born in 1972. But nevertheless, since 1972, my mother and her siblings have fought for justice. And we salute them for their steadfast perseverance in pursuit of justice and fairness. And so, what was one of the first steps they took in the pursuit of justice? Well, one of the first steps they took was to go to Mr. Murdia's office. Mr. Murdia was the lawyer for John Augustus Alexander Virgil. Remember, he helped to craft his will. Mr. Murdia looked at my mother, and he said, I don't know if he addressed that Mrs. Brown or what, but he said, why come to me? He said, well, you're his lawyer, Mr. Murdia. Why shouldn't we come to you? That was the first step that something weren't right. Later on, they went to see Mr. Walter Maddox. He's a good man. That's what we're told. From Conyers, Deal and Perman. Mr. Maddox advised the beneficiaries, go to the bank, collect your deeds. They knew process. This was the advice given to them. Next, they went to Appleby. Jeffrey Bell, he read the will. He advised the beneficiaries that there was real estate to be distributed and they should go to the bank so that the will could be executed. This is all during the early 70s, in the early days. Eventually, the bank, they met with Mr. William King at the Bank of Butterfield, and at that meeting, Mr. King advised them that there was no land to distribute. And according to the beneficiaries, like a choir, they said, well, we know that's not true. They were certain that Uncle John had left what they knew he left. They requested the bank, in their capacity as sole executor, conduct an investigation into the title. So the beneficiaries requested that the bank conduct an investigation into the title of this land. And as we know, that report into that was done by Mr. Robert Murdia on behalf of Bank of Butterfield. Now, the complaint that was filed with the Bermuda Police Force caused them to conduct, under the leadership of Thomas Casson, number 55, they conducted a criminal investigation into the activities surrounding the 1969 transaction, and they reported back in 1978, and we've drawn on that report today, as we've done on the report from the Bermuda Caribbean Engineering Consultants. We thought it was a very shrewd and smart move to retain this entity because they did a lot of the research into the ownership of the title that the beneficiaries may not have been well placed to do themselves, but nonetheless it was done and it has provided valuable insight. They took us back to 1885, straight up to today. Now, during the course of this pursuit of justice, over 25 lawyers in these little islands have been approached. Over 25, probably closer to 40, have been approached. And it's been a real mix of experiences, expenditure, a lot of money spent on lawyers, and we've had a lot of different outcomes. And the beneficiaries have written to the bank, they've written to Appleby several times during the pursuit of justice, and every time they were chased away. Sometimes they were scheduled to have meetings, and the bank would call 15 minutes before the meeting and say it's postponed. We're not having it today. Another time the bank's calling, I'm calling your mortgage in, I'm calling your loan in.
And you have examples of all those that you'll share with us?
Yes.
Okay.
I have examples. This is some of it is written, most of it is recollections.
Okay.
Now, we also made representation to a former commission of inquiry in the late 70s. Lord Pitt chaired a commission of inquiry into civil disturbances in Bermuda. And the beneficiaries made representation to Lord Pitt back in the late 70s. And I know that some members present would be familiar with that time in Bermuda's history. That's a footnote, sir.
Thank you.
Yeah. Now, in furtherance of their pursuit of justice, the beneficiaries took a closer look at Uncle John's will. And they were reminded that it was drawn up in May of 1964. And the Bank of Butterfield was appointed as the sole executor. It was governed, and this is important, the will was governed by the Trustee Act of 1876, Section 50. And there's Robert Murdia again, signing off on the will. However, the bank, they claim that they became the executor of this will, of this estate, at the time of Uncle John's death in 1972. Now, we can see from the will that they became the executors the date it was drawn up, May 1964, May 21, 1964. So that's what the bank has indicated, but we know different. Having a closer look at the bank's role as it relates to the passing of John Augustus Alexander Virgil and their responsibilities as the executor and trustee, we move on to page 49, which is the next slide, and we have a closer look. When Uncle John passed away in January 1972, the sole executor, as they are required, placed a notice in the official gazette. We've all seen these notices calling for claims. So here we are, sometime between January and June of 1972. This notice was placed in the official gazette. Now you can see from this notice, names, Uncle John, John Augustus Alexander Virgil, deceased, and it goes on to say, pursuant to the Trustee Act 1876, Section 50. That's important reference. Because the Bank of Butterfield, Bermuda's first bank, they claim to have no obligations under Section 50 of the Trustee Act of 1876. In fact, they say in their report, Betco, short for the bank, became the executor of the will of John Augustus Alexander Virgil upon his death. Now, we saw where Robert Murdia signed off on, as you saw it in 1964, the sole executor. How is it that the bank's reporting to the beneficiaries in 76 or thereabouts, that the 78 report, that They became responsible in 1972. And then they go on to cite a piece of legislation that's unrelated to the matter. But let's move on to slide 50 and have a closer look at the Trustee Act of 1876, Section 50. We won't trouble you with every word, but just know that Section 50 speaks to the trustee's responsibility regarding the distribution of assets once the executor has been notified. And it also speaks to the executor's responsibility to invite claims against the estate, and for all claimants to send in your claims. Let us know what interest you have in this estate, and for the executor to be at liberty to distribute the estate, to distribute the assets amongst the parties entitled thereto. So it's very clear in our minds what Section 50 of the Trustees Act of 1876 requires of the sole executor. How the bank says they didn't become his executor until 72 is a matter for them. We know that they were the executors at the time the will was drafted. We know they had a fiduciary and a legal responsibility under the Trustee Act of 1876, Section 50, as we've just reviewed. Yes? And so, having a closer look now at the Butterfield report. Now remember, the beneficiaries who believed that they had a legitimate claim, these are clients of the sole executor. And the sole executor has written to this client in the form of a report on the authenticity of the title of the property that they lay in claim to. And this is what the bank said to them. The bank said to the beneficiaries that this report is commissioned as a result of complaints made by certain persons. They're talking about the beneficiaries. That is sole executor. Now, it doesn't make it wrong, but it seems extremely discourteous to refer to the beneficiaries, working class people, clients, as certain persons who claim that the title to the land is in error. This is what the bank is communicating to the beneficiaries. They go on to say, this is the bank telling the beneficiaries.
And you're going to direct us later to the document from which this extract is taken?
Yes, that report has been submitted to the commission. I believe it's in.
But this is just a line, but it's taken from.
This is an excerpt from the report that was submitted.
Okay.
Yeah. So the bank indicate in their report, we do not direct our minds to the authenticity of any deeds which have been produced to us. Now just imagine that for a moment. We do not direct our minds to the authenticity of any deeds. Any. So let's be laypersons and interpret that. Now, you interpret it as you choose, but what we have interpreted is that if these documents are in front of us, we think they're good. They go on to say that all documents purporting to be original appear to be genuine. They appear to be what they purport to be, and we have no reason to doubt that they were signed by the persons whose purported signatures appear therein. This is in the 60s and 70s, and the bank is telling the beneficiaries it is what we say it is because we say so. And there will be no questions. That's how we interpreted these assertions. They go on to say that their method of dealing with the land is to show title of the persons who are there now. Imagine not starting at the beginning. Imagine not starting with the ancestors and when they first took possession of this land. You're going to start with the persons who now earn. And then the bank goes on to say with reference to a very important transaction on the southern portion of the property. Remember Eric Jones inserting himself 3 days after, or 6 weeks after the Lot 4 became Uncle Jones? Well, with respect to Eric Jones' claim of ownership, the bank, in their report, looking at the authenticity of the title, say the indenture has not been produced to us. It's missing. But we have no reason to doubt its existence. This is incredible. Let's read that again. The indenture has not been produced to us. Now, this is the indenture that confirms the legal transfer of land, and this is the sole executor in their report commissioned by Appleby's murdia. This is not ordinary folk. These are not lay people. Okay? They claim that the critical document to authenticate the sale is missing, but they have no reason to doubt its existence. Well, we have a lot of doubt, and we have a lot of reasons for that doubt, and we do not believe that that sale was even close to legitimate, and we have a lot of reasons to doubt its existence. So that's our view of the Butterfield's report, and as we take a closer look with the Butterfield report, we see here where they claim on page 52 in writing that they became the executor at the time of his death. And clearly we can see from these copies of the will, excerpts mind you, that they became the executor at the time the will was drafted. And they had a responsibility under the Trustee Act of 1876, Section 50. Okay, so that is our view on the bank's report. We're now going to take a closer look at some of the statements from the witnesses to some of the transactions that Russell Levi Perman engaged in. Now, the police report is reviewed in page 53.
You propose here to have a look at the police investigation and to critique witness statements that were taken by the police in the course of their investigation, and you wish to advance this as a reason why you say something happened that was untoward?
Correct. The evidence from the witnesses supports our position of illegal, untoward behavior.
Sorry, just 1 minute, please. Just 1 minute. No, it's okay. Whereas I generally have no objection on my part, especially the statement of a witness, it should be read together. We're not contending or challenging your analysis, but I think for us to embark upon this exercise here, I think properly speaking we should have the statements before us.
We've provided them.
Okay, but I know, but I would say let us look at them first.
Okay.
And then go to the analysis after.
This isn't an analysis of the interviews. It's excerpts,
Okay.
quotes from.
Right. But what the point I'm making, as I'm saying, I have no problem with the exercise. Normally there's a saying that the statement must be read in its context.
Okay.
So I would like to see what appears the sentence before and the sentence after.
Sure.
And I would just ask us to make a note here. Let us come back to this part after.
Sure.
But we'll do it after because I'd like to have a look at the statements before we
Okay.
embark on this part.
Certainly.
So I'll just make a note and we'll come back to it after.
Okay, so on page 54, we have excerpts from witness statements. Mr. Algernon Conway Doors, a taxi driver, he witnessed the supposed sale between Uncle John and Russell Perriman in '69. Now, Doors testifies or states to the police that he drove around and landed up in a taxi. He drove around and landed up at Monica's Mission. He was asked to sign, and he said he did, the sales agreement. He was also told by Sergeant Casson that Casson had 2 sales agreements with his signatures on it. And Doors said, that can't be right, I only signed once. And he went on to say, I definitely only signed my signature once. And I'm sure I gave 1 signature. And if two signatures, then 1 was made by someone else. These are excerpts from the witness statement of Mr. Doors. And Mr. Doors was a witness to the sale, and Mr. John Emmanuel Augustus was supposed to have purchased the property, northern portion we're talking, on the same day, April 15, 1969, from Russell Levi Perriman. And Mr. Augustus, who was a mason by trade, he said that Russell Perriman had told him about the land. And he also recalls Russell saying, I'll have to do things my way. We've seen some of that. Augustus also said that the sales agreement appeared to have a signature on it dated February 9th. But Emmanuel Augustus says he could not have signed it because he only went there on the 15th of April, 1969, not February 9th. 1969. And Emmanuel Augustus also says that Russell Perriman never showed him any deeds, sales agreements, or anything that would indicate that he owned the property. Saw nothing. And Emmanuel Augustus says that he accepted that John Swarm was dealing as his agent would know the particulars of what he was getting into. This is what Mr. Augustus has represented to the police during the course of their investigation. Over the page to page 55, the police also interviewed the 3 key players, Mr. Murdia, Mr. Wilkinson, Mr. Swan. Casson interviewed Mr. Wilkinson 28th of January 1976. And on this occasion, when Wilkinson refused to cooperate, he would not provide Sergeant Casson with access to, sight of, or even a photocopy of the February 1969 agreement. Now, this is an esteemed lawyer, Speaker of the House, told Sergeant Casson, no, you can't see it. I wonder why not. But that's what he told him, no. So it was also a document that we believe would have held Algernon Doors' signature on it. Remember, Doors said he only signed once, and Sergeant Casson knew that. So if Doors' signature was on 2 sales agreements, and he only signed once, then we've got a problem. So you want to know why Wilkinson said no? Yeah, I wouldn't have said no, but I can understand why it would be withheld. So now, Sergeant Casson also had an interview with Robert Murdia. This was a couple months before he spoke to Wilkinson. So he met Robert Murdia at his office, And murdia said John Virgil came to see him February 19th, 1969. Now, he didn't say which John Virgil, but he said John Virgil came to see him. Remember the John Virgil from Somerset that he drew the covenant up with? Yeah, the imposter, the cousin. Yeah, remember him? We suspect that's the John Virgil they're referring to, but murdia didn't mention a middle name or initial. He simply stated, and it's probably true, that John Virgil came to see him on February 9, 1969. And he also went on to say, Virgil told me send the deeds to Wilkinson. Now, with respect to John Swan and the investigation, he wasn't very cooperative either. The report concludes that the search has been in progress for a number of months by John Swan Limited for the conveyance dated April 15th. There has been no success. So the conveyance was produced later on, and we had a sight of the signatures, but it was not produced for the police investigation. And as the police wound up their investigation, this was their conclusion. He said on page 56, it is possible that John Virgil never signed the conveyance dated 15th of April 1969 at David Wilkinson's office. He was not known to Wilkinson, and indeed, Mr. Perman could have brought someone else instead. Goes on to conclude that without the original conveyance and examination of Virgil's signature, nothing further can be done at present. And it goes on to say that John Swan has started a search for this document, and as of this date, the date at 78, there had been no success. And so, just adding a bit of color to the pursuit of justice, you should know that the beneficiaries, steadfast in their approach, they wrote to the bank, they wrote to Appleby, they even wrote to the regulator of banks, the Bermuda Monetary Authority, asking for intervention, asking for assistance, constantly told, nothing here, Ms. Brown, can't help you, nothing here. In fact, the cross-section of lawyers, nothing we could do. Ms. Brown, you're causing trouble. No, you can't take these people to court. This is what was said to the beneficiaries as they pursued justice. Take the money. Oh, I can't do anything. The bank's paid me off. Or I can't do anything for you. Oh. Others said, I often wondered how John Swan got his start. So we've had a series of lawyers, but we've not had the opportunity to be heard as we are being heard today, for which we're most grateful. Further recollections from this journey. Commissioners, after 50 years, almost 50 years of pursuing justice, you run into a few obstacles. And my mother, she's led this charge, and she's run into quite a few obstacles along the way. But as you can see, she's still standing. After 48 years, she might be sitting down right now, but she's still standing. This fight continues. This journey has reached a milestone. As she pursued justice, David Wilkinson showed up unannounced down the Hog Penny. She said she'd never seen him down there before. David Wilkinson, I need at the Hog Penny, but he showed up at the Hog Penny one night and said, Miss Brown, you better watch your step. Better watch your step, Miss Brown. She watched him. She's still watching him. Soon after that, she went to see the Chief Justice in this country at the time was Mr. Osford. The Chief Justice. He told Miss Brown, you should put a match to those deeds. That's what he told my mother. You should put a match to those deeds. Charles Mann, senior manager at the bank. Now, you know he didn't put this in writing. Charles Mann said, we can offer you $154,000 to settle this thing. That's what Charles Mann said to my mom. Sir Dudley Sperling, from Appleby, Sperling and Kemp, Robert Murdia territory. Sir Dudley Sperling was the chairman of a law reform committee. They had something to do with this too. We may or may not get to that, but we'll see. But Sir Dudley Sperling said to my mother, looking over his glasses, thought he was perhaps intimidating her, but he said, Miss Brown, the ball's in your court, and you better be very careful with what you say. My mama never played tennis or badminton or nothing, but I could see her now pushing a two-handed backhand right back in Dudley Sperling's court and saying, yeah, well, here's my move. So not intimidated, soldiering on. She approached Eric Jones, and he said to her, because he was visiting Bermuda, I don't believe he stayed there. He was visiting at the time. My mother went to see him, and as the young people would say, he dissed her. He said, I didn't come here to do no business with you, and walked away. When Robert Murdia was approached, he asked, why you come to me? She said, well, the beneficiaries were clear that you were his lawyer. I knew my uncle had land, but we just didn't know about the money. So here were the beneficiaries, beating the pavement, trying to be heard. So they go to the bank, pleading with the Bank of Butterfield as executors to do the right thing. So they leave the bank and come home. Later on that afternoon, the other bank calls, Bank of Bermuda. Said, Miss Brown, this is Mr. Dudwell calling from the bank. Excuse me. Your loan is due in full by close of business tomorrow. Now, colony and loans and mortgages was chapter 1 in the playbook back in the 60s and 70s when people stepped out of line. So here's Mr. Dudwell saying, your loan is due by close of business tomorrow. Well, my mother, knowing her, the way she likes to speak, she told Mr. Dudwell, well, I tell you what, go ask John Swan, Arnold Francis, and David Wilkinson. Go ask them for the money and tell them I sent you. That's what she told him. But Mr. Dudwell called back the next day. He said, Miss Brown, just continue on. Carry on. No change. Arnold Francis. Yes, Arnold Francis called my mama up one day at home and we had 5 digits. 20286. He said, Miss Brown, what you trying to give? Joan out for the heart attack? And my mother, I heard she's smart when she's ready. She said he should have one. That's the way she was feeling. I don't think she meant ill on it, but it was frustration at the time. She even called John Swan at his house one evening. And young man answered the phone. Next thing he said, Daddy. So he came to the phone and my mother says, John said to her, I ain't having no meeting with you people, and don't you ever call her again. It's not funny, it's sad. He said, don't ever call her again, claiming ownership to property that you have the title deeds to. More recently, the bank, to Miss Richardson, she said, what? In discussing the matter with my mother, you just don't get it, huh? And you just don't understand. Now, how could you speak to a woman who's coming to you as a client with a 45-year-old complaint? And you're just about 45 years old yourself speaking to this woman in this manner. Unacceptable. Kieran Bell from Appleby asking my mother, the beneficiaries, if they're trying to say that Appleby did something wrong. I talked to Murdia. He engineered a lot. Now here's one of the residents of the property today. As of today, said, Miss Brown, if I show you my deeds, then John Swan won't give me no more work. That's what time it is. That's what we've been hearing during the course of our pursuit of justice over the years. And with that, Commissioners, I'll bring you to penultimate page of our presentation today, where we share our conclusions with you based on the evidence we've presented and our understanding of it. Eric Jones, the family lawyer, conspired with cousin Joan Alfred and Robert Murdia from Appleby to defraud John Augustus Alexander Virgil of his 4 acres of land in Spring Benning. Robert Murdia was the engineer behind this scheme to take advantage of unsuspecting people's client that owned land. He worked closely with David Wilkinson and others to execute this plan. Lawyers from Appleby and Cox and Wilkinson were hands-on with this fraudulent scheme, and they used others to execute it. There are 2 major transactions, one in 1961-62, another in 68-69. Both of these transactions are fraudulent and clearly do not meet the legal standard for a legitimate property transaction. The major players to this scheme, they obstructed justice and denied access to due process. Legalism was used to prevent anyone from being held to account. The Bermuda Police Service concluded that signatures were forged, documents were withheld, and David Wilkinson never met John Augustus Alexander Virgil, despite claiming he signed a sales agreement and conveyance with his client, Russell Levi Pearman. The sole executor of the will does not acknowledge the Trustee Act 1876, Section 50, which outlines their fiduciary and legal responsibilities as sole executor to the May 1964 last will and testament. The 1962 transaction for the southern portion and the 1969 transaction for the northern portion, with John Swan's involved, both of these transactions are rooted in fraudulent and illegal actions, and consequently, all transactions thereafter lack legal credibility. All of them. The beneficiaries are entitled to justice and compensation for being victims of this scheme. And lastly, the Virgil family have held the title deeds to this property since 1885. And to this day, the beneficiaries remain in possession of the deeds, and they claim rightful ownership to this property willed to them by their uncle John Augustus Alexander Virgil. And with that, ladies and gentlemen, we submit that these players, Butterfield, Cox and Wilkinson, Appleby, Eric Arthur Jones, David Wilkinson, Robert Murdia, Russell Levi Pearman, Edward E.T. Richards, John William David Swan, John Alfred Virgil from Somerset, Arnold Francis, and Leslie Earl Mean worked together to deprive these people, Uncle John, of his wishes and his 7 nieces and nephews of what was rightfully theirs, as outlined in his will of May 21, 1964. And with that, Chair, I conclude on behalf of my ancestors and the beneficiaries our presentation
Thank you,
for
Mr.
today.
Brown. Thank you. Council, do you have any questions at this stage?
I have many, but I am proposing that we continue on Monday.
On Monday? But will we have the adverse,
I am not certain, but I propose that we not wait on that. We provide them with a transcript.
okay,
We provide them, but we continue and we give them an opportunity to answer. So either they attend in person to put questions, or the transcript can be shared to them and they can answer, and the answers provided to the commissioners prior to a report being written. But I
Right.
proceed, we
but
continue.
of course, we have to bear in mind that justice operates both ways, and we will have to give them sufficient time to study. So if they're not able to come in on Monday, then you're not proposing that.
No, I wasn't proposing for them to come in on Monday either, because even for them to come in, they still would need a transcript before Monday to come in.
Indeed,
So
indeed.
I was thinking for us just to proceed, and then when we
Yes,
get to that point, we'll treat with it.
quite. And I take it commissioners will have some questions as well?
Yes.
Yes.
Later time.
Right. So what we propose to do, because we have matters scheduled for tomorrow, we will resume for the rest of the week. We will pick up with your matter Monday morning at, shall we say, 9:30?
At 9:30, thank you.
Yes, I can.
Because
just
all
commissioners,
the-
we usually start at 10 o'clock, but because your matter is fairly lengthy, we will start at 9:30 so that we can give you a bit more time, or give everyone some more time.
And importantly, Madam Chair, the earlier exhibits, the one which references exhibits A through to N, the exhibits 1 through to 18, all those have to be, those we just put in a schedule of them, all those exhibits now have to be tendered, which support the evidence. So we have quite some way to go.
Yes, so should we do the tender, the exhibits now, but they have,
No,
On
tender
Monday.
will take some time, Madam Chair. So, but we have the schedule in. But I think for the context of the evidence to flow, I would like to direct the witnesses' attention to the evidence and then tender the document. So I
Okay.
prefer to start afresh on Monday because it's going to
Okay.
take us some time.
very well. So 9:30 Monday morning, Messrs. Brown, and at that point, we'll see you. And please remember that you're,
speaking to.
please remember that you're on your oath, and so I'm asking you not to discuss the matter over the weekend, and we'll see you Monday morning. It's usual, yes, it's usual procedure. You know, if in fact you're testifying, and in the midst of your testimony, the matter is adjourned, then you ought not to discuss it with anyone. So I'm asking you and brother and other beneficiaries not to discuss it, and then Monday you'll be, I won't ask you to re-swear, I'll just ask you that you're still on your oath, because it should still be fresh in your minds. Okay? Thank you. I'll hear you, just speak.
My mother has not yet been sworn in.
How many more witnesses do you have?
I don't anticipate any more than 3 of us in total. My mom may have testimony, so it'll be 3 of us.
brother will be speaking on Monday. Your brother?
It depends on the questions.
Right.
So since we don't know what you would like to know, we'd like to have the team
But
available
we
to
certainly
respond.
want to know everything.
Well, we'll provide you with everything, but we're not sure who's
Or everything
saying
that's
what.
relevant, I should
Of
say.
course, of course.
Right. So, and mother may be testifying as well?
Yes.
Okay. And so it would be your brother and mother. Anyone else you anticipate?
No, that's it.
No. Okay, fine. So we will see you Monday morning at 9:30.
Thank you.
Thank you. Secretary, yes?
Yes, Madam Chair.